And Ms. Baldwin, I think I saw you on here. There we are.
Yes.
26-2-37908, Kim Marie and Erica Turner.
That's ready.
And I'm just looking here. I
She
see
is on.
Ms. Turner
She's just listed as
there.
Erica.
Hello, I'm here.
All right, I see Ms. Lachisi. This was set over from last week. Seen a lot of paperwork on this one, but counsel, you want to go ahead?
Yes, thank you. So this was set over last week to give the defendant an opportunity to respond. The court directed her to deliver a response to the court as well as to my office. She did not do so in the sense that all she provided my office was a suspicious link. We, like the court, are not going to click on a random suspicious link. Didn't provide a PDF, didn't provide a hard copy. To the credit of the clerk's office, we were able to work with them to get a copy, but only after our client's response was filed. After reviewing that response, and did Your Honor receive her response?
Excuse me, I received, I believe, 2 from your client as well as 2 from Ms. Turner. And copies of a rental agreement and a lot of other exhibits. So
okay, very good. So with that, I'm still prepared to move forward. When you look at her materials, this is a case where at this point there's over $10,000 of rental arrears. Her declaration, be it long and with many sort of random items attached, doesn't address the core issue in the case, and that is, has she paid the rental amounts? She says, like, I dispute $200 over here, but not essentially the $10,000 that otherwise exists. She doesn't provide proof of any of the payments except one, and I would argue that the proof of payment she provided is wildly suspicious, and it only is $1,000. It's not the $10,000 that's owed. In this case, we do have despite the fact she's responded, there's still a very clear case here where somebody she doesn't reference that payment either. So it's just, I'm just going to attach this for whatever the court wants to give it, type of a thing, but doesn't actually say, I made this payment, these are how I made the payments. And my client does. She says, hey, here's the last payment she made. Here was our course of conduct. Here's how we were doing it. And my client does provide that in her declaration. We don't see that on the defendant's side. We don't see her making payments that would equate to the $10,000 plus that's owed at this point. She does submit the rental agreement. We submitted a copy of the rental agreement to show that Ms. Turner doctored the rental agreement. And here's what's odd about it. So it's really clear that it was $1,100 was the amount per month, and she edits it to turn that second one into a 0. But even if that was true, it doesn't impact the fact that she's thousands in arrears. Maybe that shifts the judgment. It doesn't shift possession. So we're in a position where she hasn't paid. There's thousands and thousands owed. She has not provided the necessary materials, despite being given a significant amount of time at this point to produce them. And the vast majority of her declaration just sort of strays into things that are really irrelevant. I'll note that she references me, and to my knowledge, I haven't had contact with this person other than in professional channels, and in this case, with this client of mine, only recently, only essentially as a function of the case that's currently before the court. So she references that some random other Baldwin, there are other Baldwins in the world. That was not me. I don't have power of attorney, anyone related to this case. So again, sort of things that are really irrelevant, I would argue, but she spends a lot of time sort of going over those. So at the end of the day, there isn't a question of fact as to possession. There might be a question of fact as to the judgment. What we're asking the court to do today is provide us with possession and the writ of restitution. We can reserve judgment for a later day on whether or not it's $5,000 or $10,000 that's owed. possession first. Again, this is a case where these folks are essentially living on top of each other. So a case where there are legitimate concerns about a breach of the peace beyond the financial issues at stake. So again, we'd ask for the writ.
I was one question. Did you or your client receive payment for May?
No, Your Honor. My client, that's why she put her declaration together, is she hasn't received any payment.
I mean, since last week, since court last week.
Yes, correct. But
Okay.
she didn't receive any payment within the last 3 months. So that was true from January forward. There have been no payments. Now there are prior payments in addition, but I'm just very explicitly, there were none leading up to the filing of this case and none since the filing of this case.
Okay. Did we show anything in the clerk's registry for payment? Give me just 1 second. I'm checking with my clerk.
There isn't to my knowledge, but that might change, if she did it this morning.
Well, I'm sorry, but I do know the answer to that, obviously, because when I paid my rent, our last court hearing was May 1st, and I've always paid my rent prior to the due date. I have multiple receipts from my landlord, Your Honor. I have receipts from when I lived in the studio. I have receipts from now. I am obviously disputing all of that I owe any money. What I did show is that there's like, why would I owe her $200 for 2 years and her not say one statement? There's no communication between the petitioner and myself over me owing her $200 from 2024. There's no communication between the petitioner and myself saying that I owe her $200 in January of 2025. I put a lot of information because it's been a year since I asked for repairs, Your Honor, and I did not receive repairs. Like, I still have not received. I've been paying my rent. As a matter of fact, you'll see, I want to say it's Exhibit H, where it says that as soon as she gets, it's a text message from July 3rd or July 23rd, where she says as soon as she gets the other units rented, she'll make repairs. I turned in 2 checklists. I did not update, I don't think, the checklist of some of the repairs made, but I turned in 2 checklists of repairs that have not been made. I have talked to the city officials, and so there should be some kind of documentation that I know I have like emails to them, but they didn't. Once I had a face-to-face conversation with him, he never responded to me again. And that's when she did the railing for the lady who lived there before. And that's when she did the back wall. I did not talk to the lease. As a matter of fact, I did receive an email from Miss Baldwin late last night, and even in the text message, and in the petitioner's own message, it says $1,000. She did not send the court one message saying, "Hey, Erica, you only paid $1,000. When do I get the other $200? When do I get an extra $100?" Nowhere in any message do you see Kim asking me for, or whatever her name is, because again, I pointed out that I did give her a money order one time, and she came over and yelled at me. That's when I called the police, because I didn't give her money properly. And then she's been changing her name. Her last name was 2 different last names, and now she's Kim Marie, and she's Kimmy, and she won't take anything because it's not her proper name. And I have zero problem. I paid my rent on January 23rd. I don't know the exact date. I'll see if I have it in my calendar. Or April 23rd, sorry. It was shortly after I got these, and I asked her about them, and she didn't answer me. She didn't talk to me. She just stared at me like she didn't even know who I was. And then, but I have zero problem paying the court I'll pay him $1,100. My $1,000 for.
Ma'am, let me hold on, ma'am. Hold on a second. Ma'am, hold on a second. Let me ask you some questions. So I'm trying to understand this. I read your documentation. The Did you pay May rent since we were here last?
Well, no, we were here last on May 1st. I paid rent on April 23rd. Like we had a good relationship-ish at
Okay,
times.
hold on.
Sorry.
I'm just answer my question. So you say you pay May rent on 4/23,
Yes,
and how did you do that?
with cash.
With
She
cash?
will only take cash from me. I gave her a money order one time and she called the cop. She got mad at me and I had to call the cops because she was screaming at me.
Okay. All right.
I have zero problem giving a money order to the courts.
How much did you pay her on?
It's only been $1,000, Your Honor. She has brought people into the apartment and told them how much she could raise the rent if she got a new renter in. This is her MO, to move into each one of her properties and kick everybody out, like make them so miserable.
All right, well, here, Ms. Baldwin, is your client available to ask a question about the rent paid on the 23rd?
Yes. And Kim, if you can unmute, there you go.
Yes, I would be happy to.
Kim, can you just state your name for the court?
My name is Kim Marie.
And Kim, when it comes to payment, did the defendant in this case make any payments to you in the month of April?
No.
And has she made any payments to you in the month of May?
No.
Okay. Cash, check, in any form, has she made any payments in April or May?
She has not.
Does the court have additional questions?
Okay.
And just an additional argument, it's really clear that the receipt is effectively perjury. When you look at the rental agreement, my client's signature, if you actually look at the signature itself, it flows. When you look at the receipt, if you look really closely, that might be hard on Odyssey, but if you look really closely, the signature on that receipt that she tries to provide is shaky. And it's shaky like it's being traced. That somebody is, because I would argue that my client's cursive is, like, it's hard to do that. It's hard to fake that signature. And so when you look at the receipt book, and again, there's no prior receipts. There's no history of them using these kinds of receipts.
No, objection. That's not true. Objection.
Ma'am, hold on. I can only hear one person at a time.
So sorry, that's not true. Objection.
So again,
ma'am, hold on. I'll come back to you in a minute.
So sorry.
One person at a time, please. Go ahead.
When you look at the receipt that she provided, if you look closely at the signature, it looks very much like a trace. Like their hand is shaking because they're trying to copy over a signature. And we see the willingness to do that, not only here, but in the rental agreement. That my client's copy of the rental agreement shows $1,100 a month, and her copy very clearly on the amount per month takes that second one and makes it a zero to change the total amount per month. So here we have a willingness to deceive. And then we have, again, a receipt we don't have any prior receipts in this format. My client says this is not how we did things in her declaration. We only did it via like text and like basically acknowledging like, yes, I got it. It was in the mailbox. I got it, kind of a thing. And while informal, that does show their course of conduct. It doesn't make any sense that my client files the eviction and then hands her something that they've never done before. So in this case, and again, it doesn't make sense in a case where somebody owes $10,000 plus that my client accepts a random amount. And it doesn't make sense when there's no other tracking from this person. So there's not, here's me taking that money out of my bank account. Like there's none of that. And so there just aren't the indications of reliability for the defendant that the court would need, especially in light of all of the other evidence.
Sorry, can I go now?
You may, ma'am. Go ahead.
I will 100. I don't have all of the receipts for all of the months because that's how she does things. And yes, that is how I have, like I said, the same exact, different book, the same exact type of receipt from back when I was at the studio apartment. I have not touched anything. I have not changed anything. As a matter of fact, I gave you, Your Honor, emails where she literally says, like, I'm rereading an email and I misunderstood what the email said. And she says, I forgot that my mail was coming to my house. I forgot that my mail, twice she says that. Like, so she is actually inconsistent with these random $200 that she has, again, no evidence for. Whereas I have actual consistency and I'll provide whatever receipts I do have to the court if that's what the court wants. And I will 100% happily pay the court registry clerk, whatever, my rent payment for whatever legal name the court asks me to pay a money order. I would prefer a money order to the cashier, the clerk, and a legal name for my landlord because I don't even have a legal name for my landlord.
And for my client, like the $200 is obviously, it is not the main issue here. The main issue is the $10,000 that's owed otherwise. And again, this was her opportunity, and the court set it over for her to provide these things that she said that she had. That has not come to fruition. Where we stand is there's $10,000 plus in arrears. Again, not seeking a judgment. We can fight that another day, but possession is very much appropriate in this case.
All right. Well, it's really unclear. What's somewhat problematic in this case is I've got two copies of the rental agreement. They're different. One doesn't have either signature page. That's the one that your office provided. The one that she provided has obviously a changed number from that on the amount of rent. It does appear to be both signed by both parties.
Oh, my copy is signed by both parties.
Let me finish. Okay, the copy that I received does not have a signature page. So either that's missing. I mean, I don't have it. I've got there's only 3 pages in the attached that I have.
Okay, I can provide that immediately. So what we sent did, and somewhere maybe that got misplaced, but I'm very happy to provide my copy that does have those signatures.
Okay. That may be. I'm just saying I don't have that here in front of me. I also don't have any of these. I have one receipt that was attached to a rental agreement that Miss Turner provided, and the signature on that receipt looks to me like it's the same signature as on the lease. So, I mean, if that payment was made, and it says it's in May 26 for the month of May 26. So, and that would be for this month. So I don't know who's telling me the truth here. I've got a receipt that looks, I mean, the signature on that document looks the same as the lease agreement that I have a copy of.
And I'm willing to pay a money order to whomever the court requests. I pay an actual money.
Hold on. What I don't have is I don't have any proof of any other payments other than a couple of texts that say the mail's in the money's in the mail or in the box. Ms. Turner,
am I allowed to say?
Wait, Ms. Turner, this receipt that you provided, when did you get that receipt?
I believe it was, I'm not exactly positive of the date, but I'm pretty sure it's really close to April 23rd because it was after I received the documents and I tried to talk to her about the documents. And you can see in our text message, and I have way more evidence of times of me trying to talk to her. Everything I said in my statements, I am willing to prove. I gave you the police report number from when and then that tracks the previous harassment and stalking that like I ignored and I let, pass up until she became aggressive and violent. And again, I'm sorry for,
Okay. Well, hold on just a minute. I guess, I mean, it concerns me. I've got a receipt that that appears to be signed by your client for this month. That was, and I don't have a date of when it was done, but it says for the month of May 26. And she's telling you that she didn't get the rent. So that's concerning.
I mean, I agree. When we came before the court, I said I wanted the funds paid to the clerk's registry. She hummed, hawed, and then said, I've paid the rent already. So again, from our side,
I didn't hear. I mean, I told her she could pay it into the registry or pay your client direct when we were here last week for the month of May. I didn't know that it had been paid or alleged to be.
She said that last week.
I tried to tell you guys last week, but
hold on.
Hold on. I'm so sorry. I understand.
Okay. I'm inclined to set this on for hearing just simply because I've got some contradictory evidence here that raises some factual questions.
All right. I would ask that we set it on for hearing. I'd ask for that hearing to be live and in person. I think that there's, especially when you have issues of integrity and honesty, should be in person. And especially if there's.
I don't disagree. My thought would be to put this on the assignment docket so we can get this assigned as quick as we can.
Okay.
So the 13th at 9 o'clock.
All right. Very good.
All right, Ms. Turner, that is a Zoom docket. That will be a date when court administration will, set an actual hearing date, which I will likely be very quick given the nature of the type of case this is. And that would be, again, Ms. Baldwin, if you can request with court admin that is an in-person hearing, I think that would be a lot easier to manage for everybody.
And then in addition, I would ask for a bench order that, because those hearings are usually quick, but I can't guarantee when they will be, that she's required to pay all for the rent to the clerk registry so that there aren't these questions moving forward.
Can I get something that has her legal name in it so that I can because then when you get a money order, they ask you their address, their name, their phone number, things like that. I have her phone number and I have her address, obviously, but I asked Mrs. Baldwin what her information was and she refused to give it to me.
Ms. Turner, hold on a second. If you make any additional payments, those should be made to the court registry or Kim Marie, because that's the legal name that's filed on the case.
It would just be under the cause number. I don't think that they attach it to anybody but the cause number.
Yeah, so however they do that, but that's the legal name that you would put on it if you want a reference line and put the court case number, bring it into the court clerk. And that would be, at this point, that would be assuming we get a hearing after this month. I'm expecting, and I'm going to ask court administration to set this quickly because it needs to be heard.
Okay, so on the 13th, what do I need to bring?
You need to make sure you have your calendar so you know when you're available for a trial date.
Okay, and then I know how long I'll have to be prepared for a trial? Because I don't have an attorney and literally I have documents that say Baldwin and my landlord told me who Baldwin was.
I cannot give you legal advice. I can tell you should probably contact an attorney and get some legal advice. And you should do that as quickly as you can.
Okay, thank you.
Okay. 13th at 9 o'clock.
Very good.